They were called monsters, murderers, and threats to society. Juries condemned them. Governors signed their deaths. But what if they were innocent? What if the state killed the wrong man, again and again? This isn't fiction. These are real cases, every single one ending in execution, where innocence was not only possible but likely. From botched arson investigations to vanishing alibis and recanted testimonies, each case leaves behind a haunting question. Did America kill someone who didn't commit the crime? Case after case proves one chilling truth. Being innocent isn't always enough. If you're drawn to hard-hitting true crime stories that reveal the cracks in the justice system, subscribe and like the video. You won't believe how far these stories go. Case 1. The Doubt in Texas, Carlos de Luna. On a February night in 1983, a Corpus Christi convenience store became a crime scene. Clerk Wanda Lopez had just placed a frantic 911 call reporting a man with a knife. Moments later, she lay bleeding behind the counter. Police swarmed the area and quickly apprehended a suspect hiding beneath a truck, 20-year-old Carlos de Luna. He was shirtless, breathless, and carried no weapon, but within hours, he was charged with capital murder. De Luna insisted he was innocent. He told police another man, Carlos Hernandez, was the real killer. But investigators scoffed at the claim, calling Hernandez a phantom. The prosecution relied heavily on eyewitness testimony and de Luna's suspicious behavior, while dismissing inconsistencies. There was no blood on de Luna's clothes. No fingerprints tied him to the scene. The murder weapon was never linked to him. During trial, prosecutors painted de Luna as a violent criminal. The jury took just hours to convict and sentence him to death. In 1989, after exhausting appeals, he was executed by lethal injection. Years later, journalists from the Chicago Tribune revisited the case and uncovered a chilling truth. Carlos Hernandez was real. He had a lengthy record of violent crimes, used the same kind of weapon found at the crime scene, and had even boasted about killing Lopez. Worse still, he bore a striking resemblance to de Luna. The revelation sparked outrage. Legal experts called the case a catastrophic failure. No physical evidence had linked de Luna to the crime, and key exculpatory details were ignored or dismissed. Carlos de Luna went to his death proclaiming his innocence. Today, his name is etched into the annals of wrongful execution, an unsettling reminder that doubt can die just as easily as guilt. But Carlos de Luna wasn't the only one. In another Texas case, the truth came undone. Too late to matter. Case 2. The Phantom Witness, Ruben Cantu. At 17, Ruben Cantu had his whole life ahead of him. But in 1984, a botched robbery in San Antonio, Texas, changed everything. 2 men were shot, one fatally, and the surviving victim pointed to Cantu as the gunman. Cantu was tried as an adult, convicted of capital murder, and sentenced to death. But there was a problem. Ruben had no criminal record, and no physical evidence linked him to the crime. His alibi, he was at home, miles away, was brushed aside. The prosecution's case hinged entirely on the testimony of one man, Juan Moreno, the surviving victim. During trial, Moreno identified Cantu in court, and that was enough. In 1993, Cantu was executed. He was 26. But in 2005, Moreno recanted. He admitted he had felt pressured by police and feared for his own life. He said he had never been sure Cantu was the shooter. Further investigation revealed that another suspect, David Garza, had bragged about committing the crime with a different accomplice. Even the district attorney who prosecuted Cantu later expressed grave doubts about his guilt. The Cantu case is a glaring example of justice gone wrong. Eyewitness error, prosecutorial pressure, and teenage vulnerability collided in a courtroom that seemed more focused on conviction than truth. Ruben Cantu may have died for a crime he didn't commit, and the system still hasn't answered for it. Another young man, another lie, another death. The cycle of error didn't stop there. Case 3. DNA denied. Claude Jones. In 1989, a liquor store owner in Point Blank, Texas, was gunned down. Authorities quickly focused on Claude Jones, a career criminal with a long rap sheet. At trial, prosecutors argued that Jones had entered the store, demanded cash, and shot the clerk in cold blood. The evidence? A single strand of hair was found on the counter, allegedly belonging to Jones. That strand sealed his fate. In 1990, Jones was sentenced to death. But Jones always maintained his innocence. He claimed he was waiting in a car while someone else went inside. Despite the gravity of the sentence, no DNA test was performed on the hair, only a visual comparison by an FBI analyst. For years, Jones and his lawyers begged for DNA testing. Texas refused. On December 7, 2000, Claude Jones was executed by lethal injection. 3 days later, a judge granted the DNA request, too late to save him. In 2010, the DNA results came back. The hair didn't belong to Jones, it belonged to the victim. The revelation ignited national controversy. Civil rights groups called for a moratorium on executions. Legal scholars questioned how such flawed evidence could override reasonable doubt. The state of Texas never reopened the case. Jones's death stood. Claude Jones's execution marked one of the most chilling examples of how denial of forensic testing can lead to irreversible tragedy. A life ended, a mistake made, and no way to make it right. Claude Jones asked for DNA testing. The state refused. By the time they said yes, he was already dead. Case 4. The confession question. Cameron Todd Willingham. December 23, 1991, Corsicana, Texas. Flames engulfed a small home. Inside were 3 children, all under the age of 3. Cameron Todd Willingham, their father, managed to escape. But the children perished in the fire. In the chaos that followed, grief turned to accusation. Fire investigators declared the blaze arson. They cited patterns on the floor as signs of accelerants, the intense burn damage as proof of intent. Willingham was arrested, charged with capital murder, and in 1992, sentenced to death. Willingham insisted on his innocence. He claimed the fire was accidental and that he had no reason to harm his children. But the evidence mounted. A jailhouse informant said Willingham confessed to setting the fire. Prosecutors pointed to his tattoos and heavy metal posters as signs of a depraved mind. In 2004, Texas executed Willingham. But before the lethal injection, the truth was already unraveling. Independent fire experts re-examined the case and declared the original investigation deeply flawed. What had been called arson was more likely the result of a typical house fire. There was no accelerant, no conclusive proof of intent. The informant later recanted, admitting he lied to reduce his own sentence. The case prompted national outrage. The Texas Forensic Science Commission began investigating. Until then, Governor Rick Perry replaced several members and halted the probe. Today, the Willingham case remains one of the most debated executions in U.S. history. A father who may have been wrongly accused, vilified, and put to death for the tragic loss of his own children. What if science could have saved a father from the execution chamber? For Cameron Todd Willingham, fire forensics told the wrong story. Case 5. Forgotten evidence. Troy Davis. In 1989, Officer Mark McPhail was shot and killed in Savannah, Georgia, while intervening in an assault. The man arrested for the crime, Troy Anthony Davis. He was 19. At trial, Prosecutors presented no physical evidence, no weapon, no fingerprints. The case hinged entirely on eyewitnesses. 9 people testified that Davis was the shooter. That was enough to secure a conviction and a death sentence. But in the years that followed, something extraordinary happened. 7 of those 9 witnesses recanted their testimony. Some alleged police coercion. Others claimed they had been pressured or misled. One even implicated another suspect. The doubts surrounding Davis's guilt became international. Amnesty International, the Pope, former President Jimmy Carter, all pleaded for clemency. But Georgia courts remained unmoved. On September 21, 2011, after 4 scheduled execution dates and 1 rare U.S. Supreme Court intervention, Davis was executed by lethal injection. His final words were chilling. "I am innocent. I did not have a gun." Troy Davis's case remains a lightning rod for death penalty debate. Without DNA, without forensic certainty, and with witnesses recanting en masse, the execution became a symbol of what happens when a system doubles down on doubt instead of truth. 7 witnesses took their words back, but the court never looked back. The next case might be the most heartbreaking of them all. Case 6. The Vanishing Alibi. Joe D'Ambrosio. Joe D'Ambrosio spent 20 years on Ohio's death row for a crime he didn't commit. In 1988, 19-year-old Tony Klan was found murdered in a Cleveland park, his throat slashed, his body dumped in a creek. D'Ambrosio was quickly arrested, along with 2 others. But from the beginning, something was off. There was no physical evidence tying D'Ambrosio to the murder. The prosecution relied on testimony from a man with a known vendetta, one who struck a deal to avoid charges himself. Crucial exculpatory evidence, medical reports, eyewitnesses, even FBI information was withheld from the defense. D'Ambrosio was convicted and sentenced to die. He sat in solitary confinement for 2 decades, waiting for the state to kill him. In 2006, a federal judge reviewed the case and uncovered the withheld evidence. The conviction was overturned. The judge's ruling was scathing. Had the jury seen the suppressed evidence, D'Ambrosio would never have been convicted. The state tried to retry him, but in 2012, the charges were dropped. After 22 years, he walked free, scarred but exonerated. Though he was never executed, D'Ambrosio's case underscores how close the justice system can come to a deadly mistake. Had he not fought for his innocence, he might have died behind those prison walls, another innocent man executed by the state. He was spared the needle, but only barely. Unlike the next case, where youth and race made justice impossible from the start. Case 7. Executed, then exonerated. George Stinney, Jr. It was 1944 in Alcolu, South Carolina, a town divided sharply by race and suspicion, when 2 young white girls, 11-year-old Betty June Binnicker and 7-year-old Mary Emma Thames, were found beaten to death near a railroad track. The search for a suspect was swift and horrifying. George Stinney, Jr., a 14-year-old black boy, became the prime suspect. He was barely 5 feet tall, weighed just 95 pounds, and had no lawyer present during questioning. Within hours of being taken into custody, police claimed he had confessed to the murders. No written confession was ever produced. No physical evidence tied him to the scene. His trial lasted less than a day. Stinney's defense presented no witnesses. An all-white jury took just 10 minutes to convict. He was sentenced to die by electric chair, the youngest person executed in the U.S. in the 20th century. On June 16, 1944, George Stinney, Jr. was strapped to a chair far too large for his small frame. A Bible was used as a booster seat. The executioners struggled to adjust the headpiece. When the switch was flipped, the oversized apparatus slipped off mid-execution. 70 years later, a South Carolina judge vacated Stinney's conviction, calling it a profound injustice. Their names are etched in court records, but also in history's growing ledger of irreversible mistakes. In the pursuit of justice, the system made choices that ended lives on shaky ground. Whether it was faulty forensics, coerced confessions, or ignored evidence, these stories demand accountability. Because once the sentence is carried out, there's no appeal from the grave.